Good afternoon. My name is Hassan Nasir and my University at Hertfordshire ID is 240-56049. In this presentation, I will be advising Sulayman, a restaurant owner, on his rights and remedies under the Sales of Goods Act 1979 in relation to the furniture he purchased from the Amjad Furniture Store. This problem arises because the items supplied by Amjad Furniture Store, the marble tables, velvet chairs and a leather sofa, did not match what was agreed at the point of sale. Since this is a business-to-business contract, the relevant legislation is the Sales of Goods Act 1979, which talks about the terms, delivery obligation, rules on acceptance and remedies available to Sulayman when goods are defected or not as told. Now, first things first, we will discuss the contract of sales under the Sales of Goods Act 1979. To begin, a contract of sales of goods is a contract in which the seller agrees to transfer the property in goods to the buyer for money, consideration, or in any words price. Here, property means ownership, not simply possession. The furniture purchased by Sulayman qualifies as goods under section 61 subsection 1, which includes existing specific goods such as the tables and chairs, and therefore the transfer of the property normally occurs according to the rules of passing of property. Now we will see the implied terms relevant to the dispute. According to the case, some of the most relevant implied terms in these situations are section 13, goods must match the description. The second one is section 14 subsection 2, goods must be satisfactory quality. The third one is section 14 subsection 3, goods must be fit for any particular purpose made known to the buyer. Now the fourth one is from sections 27 to sections 30, obligations relating to delivery and quantity. Now the fifth one is section 15A, limitation of rejection rights for slight breaches in commercial contracts. Now the sixth one is section 35, rules governing acceptance of goods. Now the last one is section 53, recovery of damages. These provisions included with a few more can be applied to each item of the furniture. Now we will discuss the marble tables. When Sulayman ordered 25 extra grey marble tables, a specific order based on both description and quantity. The goods delivered to Sulayman were visibly different from what he ordered. 10 medium-sized marble tables, 9 wooden tables and only 1 extra large grey marble table, which was actually the order. Now we will see the section 13, which is sales by the description, says goods that are requested by a specific description must match the description given by the seller. Two famous cases that show this are Remore and Co., where goods packed in a different quantity per case constituted a breach, even though total quantity was correct. Now the second case is Arcus versus Ronason, where timber that was only slightly off the specified measurement was treated as non-compliant. Compared to those cases, the breach here in Sulayman's case is far more serious. The tables differ not only in size but in material and color, which changes the nature of goods. There is no doubt that section 13 is breached. Now we will see the section 30, wrong quantity. According to section 30, if the seller delivers fewer goods than the contracted for or delivers of mixture of correct and incorrect goods, the buyer is allowed to reject all the goods which were delivered. Since Sulayman received only 1 of 25 correct tables, this case is considered substantial and not trivial because it undermines the purpose of the contract, the renovations of a restaurant. The seller cannot argue that rejection is not allowed under section 15A because section 15A only limits the right to reject if the breach is slight or trivial. Now we will discuss the remedies for the table. For the tables, the problems are very serious because Sulayman received the wrong size, the wrong type of material and not enough of them. Since the delivery does not match what he ordered, he has the right to reject all of the tables and does not have to pay for them. He can also claim money back for any extra costs or delays this causes, such as having to find the replacement tables or postponing his restaurant renovations. The law allows full rejection in situations like this because the goods cannot be used for the purpose they were brought for. Now we will look upon the velvet chairs. Coming to the velvet chairs, if Sulayman was told they were ex-display items that were reduced in price because of minor wear and tear and were good of delivery and use. Even though Sulayman opened only one box, upon opening the box, he discovered the grease marks and visible scuffs exceeding what had been disclosed by the seller. Now we will see this section 14 subsection 2, satisfactory quality. Section 14 subsection 2 imposes an objective test Goods must meet the standard and reasonable person would consider satisfactory, taking into account the description, price, and all other circumstances. Even though the chairs were ex-display with minor wear and tear, the seller did not in any way state significant staining or damage. The defects discovered by Sulayman undermine the product's appearance and condition, meaning they are not satisfactory of quality. In the case of Rogers versus Parrish, the court concluded that even relatively small defects in a new Land Rover were sufficient to breach the satisfactory quality requirement because they affected the buyer's reasonable expectations. The same principle applies here. The defects go beyond what Sulayman was led to expect, constituting a breach. Now we will look upon the section 35, inspecting and acceptance under section 35. Has Sulayman accepted the chairs? A key issue is whether Sulayman has accepted the goods under section 35. Acceptance occurs when the buyer accepts the good or the buyer retains the goods for an unreasonable length or time without rejecting them. Sulayman, on the other hand, did not inspect all the chairs but discovered problems immediately and notified the seller without the delay. Therefore, acceptance has not occurred. Along with the similar case, Bernstein versus Pampson Motors 1987, which highlights the importance of a reasonable opportunity to examine goods before acceptance. Now we will see the remedies for the chair. In relation to the chair, Sulayman has several remedies available to him under the Sales of Goods Act 1979 because the chairs were delivered with grease marks and visible scuffs that went beyond that was disclosed at the time of sale. He may choose to reject the entire batch of the chairs or alternatively reject only the defective ones while keeping the rest. He may also seek a reduction in the price to reflect the diminished quality or claim damages to cover the reasonable cost of cleaning, repair or replacement. Importantly, all of these remedies remain available because Sulayman has not accepted the chairs within the meaning of section 35. He only opened the one box, discovered defects promptly and notified the seller immediately. Therefore, he retains full range of remedies associated with non-conforming goods. Now here we come to the leather sofa. The most significant issue with the order concerns the leather sofa. Before purchasing it, Sulayman specifically asked whether the material would irritate someone with skin sensitives. Salman reassured him it would not. After delivery later in the evening, Sulayman's daughter sits on the sofa and begins to itch. She develops a red rash on her body through the night, indicating a reaction to the material. Now we will put our glimpse on section 14 subsection 3, fitness for a particular purpose. Under section 14 subsection 3, three conditions must be satisfied. The first one is the buyer makes a particular purpose known to the seller. The second one is the buyer relies on the seller's skills and judgment. And the third one is the seller supplies the goods in the course of business. Now in this case, the purpose suitability for someone with the sensitive skin was clearly communicated. Sulayman relied on the seller's expertise, specifically asking for reassurance, which was provided. The seller was acting in the course of business. The leading case, Grant versus Australian Knitting Mills, is highly relevant here, where the buyer developed dermatitis after wearing underwear bought on reliance of the seller's skill. The court held that the goods were not fit for the purpose. The same reasoning applies to the Sulayman sofa. Now we will see the section 14 subsection 2, satisfactory quality. The sofa also fails the general requirement of the satisfactory quality. Goods that cause physical reactions cannot reasonably be considered safe or acceptable. Now remedies for the sofa is Sulayman is entitled as the sofa. Sulayman has the fully right to reject all items because that caused her daughter an allergic reaction, despite the sales advisor assuring him that the sofa would not irritate anyone with the skin sensitives. Since the sofa was not fit for the purpose, Sulayman explained he under no circumstance have to pay for it and can also claim damages for any loss incurred, including medical costs or inconvenience caused from the reaction. Now the seller's statement too late to cancel. After Sulayman raised all these issues, the seller claimed it was too late to cancel. Legally, this is incorrect. Under section 35, Sulayman has not accepted the goods. He inspected them before the extent reasonably possible and raised concerns immediately. Because the acceptance had not taken place, the right to reject all items remains available. Case law such as Clegg versus Anderson reinforces the rejection is still possible even after some time provide the defect was not known earlier and no act of acceptance was occurred. Therefore, the seller cannot insist that the contract is final or the payment must be made. Now, the last thing is damages under Section 53. Beyond the right to reject, Sulayman is entitled to the damages under Section 53, which covers direct financial losses, irrational costs incurred, and foreseeable consecutional losses. Possible recoverable losses include under Section 53. Sulayman is entitled to claim damages for the financial losses caused by the breaches. These damages may include the cost of replacing furniture, losses arising from the delays from the restaurant renovations, any impact on reopening the business income, and reasonable medical expenses related to the sofa. The purpose of damages is to place Sulayman in the position he would have been in had contract have properly carried out. The damages aim to place Sulayman in the position he would have been in had the contract been properly performed. To conclude, the facts demonstrate several significant breaches of the Sales of Goods Act 1979. First, the tables clearly breach Section 13 as they do not correspond with the description, and Section 30 due to the delivery of the wrong quantity and a mixture of goods not agreed in the contract. Second, the chairs breach Section 14 subsection 2 because they fall below the standard satisfactory quality, and importantly, they have not been accepted within the meaning of Section 35 as Sulayman had not yet inspected them fully and raised his concern promptly. Third, the sofa breaches both Section 14 subsection 2 regarding satisfactory quality and Section 14 subsection 3 relating to fitness for a particular purpose. Sulayman made a specific concern about the skin irritation clear, relied on the seller's reassurance, and the sofa failed to meet the requirements. Taken together, these breaches are substantial rather than minor. Therefore, Section 15A, which limits the right to reject in cases of slight or trivial breaches, does not apply. Sulayman retains the full-fledged right to reject all the three categories of the goods, refuse to make the payment, require Amjad Furniture Store to collect the items, and seek damages under Section 53 for losses arising for the breach. To protect his position, Sulayman should put his rejection in writing, preserve all evidence